Good morning, good afternoon, and good evening. Welcome to this seminar run by 39 Essex Chambers on the implications of the decision of the Supreme Court delivered last Friday in the Halliburton case on international arbitration moving forward. My name is Paul Darling. I'm barrister and Queen's Counsel at 39 Essex Chambers. I practice both as an advocate and as an arbitrator in commercial and construction matters across the world, particularly in the Middle East and in Southeast Asia. Together with David Bateson and David Brynmore Thomas, about whom you will hear in a moment, I am one of the joint heads of the Commercial and Construction Group at 39 Essex Chambers. We've put together a panel this morning London time, though I know others of you are in different jurisdictions, to consider the implications of this decision. The first member of the panel is Edwin Glasgow. One of the great things about these seminars is it gives you a chance to remind yourself about your own colleagues. Described by one of the directories as a legend in his own lifetime, Edwin has a worldwide dispute resolution experience over many, many years, including being the founding chairman of the Singapore International Mediation Centre. He's been involved in and appeared in tribunals of all types, of all sorts, arbitral and otherwise, around the world. Second member of the panel is David Bateson, a very distinguished Hong Kong solicitor for many years at the absolute sharp end of developments in that part of the world, who has transitioned into being one of the world's leading international arbitrators. He's based in Singapore, but conducts arbitrations throughout the world. Third member of the panel is David Brynmore Thomas, a former solicitor, Queen's Counsel, advocate and arbitrator, academic. He is a professor in commercial law at Queen Mary University, London, and has a wide practice both as counsel and arbitrator, including being on the American Arbitration Association panel. Fourth member is Karishma Vora, a barrister in England, India, and DIFC, who joined 39 recently. She has a wide-ranging arbitration practice, both within arbitration and enforcement across the world. She was for years in practice in Bombay and still, during the English court vacations, practices out of her own chambers in India. Vivek Kapoor is a dual qualified barrister who recently joined 39, having 8 or so years in private practice across distinguished firms, both in Singapore and in London. Before that, he was a member and continues to be a member of the Bar of India. He has a wide-ranging practice as an advocate and advisor in international arbitration. Last, but in no sense least, because she is going to be delivering for us the 15-minute summary of this long-awaited and much interested decision of the Supreme Court, is Ruth Keating, another member of 39 Essex. She took a first-class degree from Trinity College, Dublin, and is a member both of the English Bar of England and Wales, to be absolutely accurate, and a member of the Irish Bar. She has a thriving commercial practice in 39 Essex, following on from 2 important public jobs. First of all, she was a judicial assistant in the Supreme Court. That will no doubt help the analysis. And she's also a research assistant, even though she left before this case. She's also a research assistant at the Law Commission. The format of this seminar is going to be that Ruth is very kindly going to give us 10 to 15 minutes summary of the principles. I'm then going to ask Edwin Glasgow to give a very quick overall reaction, and we will then dig down into the various implications. We'll keep to time, and if anyone has any questions, they can put them in the Q&A function, and we will endeavour to deal with them. So without more ado, Ruth, could I ask you, please, to give us a summary of the salient points of this important decision?
Thanks, Paul. As Paul has outlined, we now have what has been a very long-awaited judgment of the Supreme Court. In terms of a quick overview, it's a unanimous judgment and it dismisses Halliburton's appeal. The judgment was delivered by Lord Hodge, with whom Lord Reid, Lady Black, and Lord Lloyd-Jones agreed. And there's also a brief concurring judgment by Lady Arden, and we'll go through all of those in terms of the main principles. In terms of the facts, they'll be well known to all of those listening. And so by way of brief background, the appeal relates to an arbitration which arose out of damage caused by an explosion and fire on the Deepwater Horizon drilling rig in the Gulf of Mexico. There are numerous relevant parties to the appeal. BP was the lessee of the Deepwater Horizon rig. Transocean owned the rig and provided crew and drilling teams to BP. And the appellant before the Supreme Court, Halliburton, provided cementing and well monitoring services to BP. In terms of the contractual background between the parties, that is of importance to the appeal. And in this case, Halliburton had entered into a Bermuda form liability policy with the respondent to the appeal, Chubb. And in turn, Transocean was also insured with Chubb, and similarly by a Bermuda form policy. Of course, in terms of the background to this case, and as those listening will be aware, the Deepwater Horizon disaster unsurprisingly resulted in numerous claims, and that concluded between BP, Transocean, and Halliburton. Following a trial in the US, judgment was given apportioning blame between the parties, and in turn, Halliburton then settled the claims against itself. But following this, we now have the stage set for the dispute at the heart of this appeal. Halliburton sought to claim against Chubb under the liability policy, but Chubb refused to pay. Transocean similarly made a claim against Chubb, and Chubb likewise contested Transocean's claims. And so arbitration was commenced. In terms of selecting an arbitrator, both Halliburton and Chubb had their choice, but they were unable to agree on the appointment of the third arbitrator. And so we had the contested hearing before the High Court. The arbitrator proposed by Chubb was ultimately appointed. And this is the real importance of the case. Subsequently, and without Halliburton's knowledge, the arbitrator accepted appointment as an arbitrator in two separate references, also arising from the Deepwater Horizon incident. The first appointment was made by Chubb and related to Transocean's claim against Chubb, and the second of those references was a joint nomination by the parties involving a claim by Transocean against another insurer. In terms of the appellate history, which we have before the Supreme Court, on discovering the arbitrator's appointment in the later references, Halliburton applied to the court under Section 24 of the Arbitration Act to remove him as arbitrator, and that application was refused. We then have Halliburton renewing its challenge before the Court of Appeal, and the Court of Appeal held that while the arbitrator ought to have disclosed his proposed appointment in the subsequent references, an objective observer would not in the circumstances conclude that there was a real possibility of him being biased, and the appeal was therefore dismissed. And finally, in terms of the concluding leg of the appellate history of the case, Halliburton then renewed its challenge before the Supreme Court. And now, of course, we have that long-awaited judgment. In terms of an overview for everyone at the outset, the court has dismissed the appeal, but the reasons which given, although similar to the courts below, do differ in terms of some important respects. In terms of a headline point, the court held that as at the date of the hearing to remove the arbitrator, the fair-minded and informed observer would not conclude that circumstances existence which gave rise to justifiable doubts about his impartiality. And so that's really the core of the reasoning of the Supreme Court. At the outset, in terms of the context of the appeal, I would also note that in assessing the judgment and its implications, it's important to keep in mind this factual backdrop of Halliburton, because of course it concerns multiple appointments with overlap. But what it doesn't speak to directly, of course, are other potential conflicts which frequently arise. It doesn't speak to arbitrations with overlap, multiple appointments in string arbitration, but of course the principles in this case are of wide interest, and of course those principles are also of much wider application. In terms of the two questions before the Supreme Court, Halliburton put first whether and to what extent an arbitrator may accept appointments in multiple references concerning the same or overlapping subject matter with only one common party, without thereby giving rise to an appearance of bias. And the second question for the Supreme Court was whether and to what extent the arbitrator may do so without disclosure. So taking those two grounds briefly in turn, on the first, whether and to what extent an arbitrator may accept appointments in multiple references, the Supreme Court held at the outset that there may be circumstances in which acceptance of multiple appointments with overlap with only one common party might reasonably cause the objective observer to conclude that there is a real possibility of bias. And so that is the real base rock of the Supreme Court's decision. In terms of the law, the court therefore held in terms of the test that the objective test of the fair-minded and informed observer applies, and that this test applies equally to judges and arbitrators. And equally, in applying the test, it would be wrong to have regard to the characteristics of the parties to the arbitration. In terms of the characteristics or qualities between the general common law and arbitration, in the court's view, there is no difference between the test in section 24, 1 subsection A of the Arbitration Act, which speaks to the existence of circumstances that give rise to justifiable doubts as to the arbitrator's impartiality, and the common law test, which is, of course, the fair-minded and informed observer would conclude there's a real possibility of bias. However, in applying that test to arbitrators, the court did hold that it is important to bear in mind the differences between judicial determinations of dispute on the one hand and arbitral determinations on the other hand. And in sum, they refer to a number of brief points on this. The first is that they said that arbitration is, of course, generally conducted in private, and so this does put a premium on frank disclosure. The second is that an arbitrator is not subject to appeals in the way that a judge is on issues of facts and often not on issues of law. And so there are limited powers of review. And again, the Supreme Court thought that was of note. Third, unlike judges, arbitrators are privately paid. And so necessarily nomination of an arbitrator gives the arbitrator a financial benefit. Fourth, the court did note the diversity of backgrounds that arbitrators can have. And this does relate, of course, to the experience arbitrators have, the jurisdictions and legal traditions. And so this might mean that there can be divergent views on what constitutes ethically acceptable conduct, in the words of the court. Fifth, the party which is not common to the various arbitrations has no means of informing itself of the evidence before the other tribunal, nor the legal submissions that were made. And the court did highlight that this is very different to a decision or a hearing before a judge, where any party may simply go in and sit in on the proceedings. And finally, the court noted that in arbitrations where the party has, or one party has, an expectation that the party nominated arbitrator will be predisposed to before it, it makes it even more important that the chair of the tribunal has a role in making sure that it is impartial and fair. We then move to the second ground, which is disclosure, and this is another important nub of the decision. And what the Supreme Court held here was that where the hypothetical observer would conclude that the circumstances as and at the date the duty arose might reasonably give rise to a possibility of bias, the arbitrator will be under a legal duty to disclose such appointments. And that, of course, was a difference between the High Court's judgment and the Court of Appeal's judgment. Importantly, in terms of the legal obligations that can arise, it is sufficient that the matters are such that they are relevant and material to such an assessment of the arbitrator's impartiality and could reasonably lead to an adverse conclusion. And so it's important to keep in mind that when matters disclosed fall short of matters which would cause the informed observer to conclude there was a real possibility of a lack of impartiality, that there will still be something which will have to be disclosed by the arbitrator. And additionally, on that point, the duty of disclosure is not simply good arbitral practice. This is a point which has been cleared up by the Supreme Court. It is a duty in English law, and it's a component of the arbitrator's statutory obligations of fairness and impartiality. The court added that the failure to make disclosure does not necessarily lead to a removal of the arbitrator. And that's an important context in which to see the reasoning of the decision. But of course, the failure to disclose is a factor that the fair-minded and informed observer would consider when making a determination. Equally, on the flip side, it's not a panacea. If a matter would give rise to a justifiable doubt as to an arbitrator's impartiality, the disclosure of that matter would not, as a general move, just remove this conflict. What we can see when we look then at the Supreme Court's analysis of this duty of disclosure in the context of arbitration is that there are clear tensions which can arise between the duty of disclosure on the one hand and the duty of privacy and confidentiality, which are of course owed. And so the court did address this. The court held that the duty to safeguard privacy and confidentiality in English law ranks above the legal duty of disclosure, and so it does not override the confidentiality obligation. But in terms of practice and how we apply this, the court said that what this means is that the consent of the parties to disclose the existing appointment in a subsequent appointment must be sought unless it can be inferred. And in terms of the circumstances where it can be inferred, the Supreme Court went on to say that, for example, the parties might have submitted themselves to certain arbitral rules by a specific institutional body, and those rules might include an obligation of disclosure. So they're the kinds of things which arbitrators and parties alike will have to think about in the future. Briefly, in terms of the concurring judgment from Lady Arden, on the whole, looking at her judgment, it supports Lord Hodge's judgment. But what that judgment seeks to do is clarify, and I would say qualify, some of the points in Lord Hodge's conclusions. Picking up the headline points, Lady Arden added that unless the arbitration is one where there is an accepted practice of dispensing with the need to obtain parties' consent, the arbitrator should proceed on the basis that a proposed further appointment involving a common party and overlapping subject matter is likely to require disclosure. And the second point which Lady Arden added is that general high-level disclosure about a proposed appointment in further arbitrations can be made without any breach of confidentiality by simply naming only the common party, which may be taken to have consented to the disclosure, but not the other parties to the arbitration. So we can see some qualifications to Lord Hodge's analysis and Lady Arden's judgment. So to wrap up in terms of the court's findings and to make way for the discussion, the Supreme Court held that the arbitrator had breached his legal duty of disclosure in this case. But in terms of the appointment, one should look at the fair-minded and informed observer test. And if they had considered the question at or around the date of his acceptance, they may well have concluded that there was a real possibility of bias. But in the court's words, it was not necessary to express a concluded view on this, as was not the correct time to ask the question. In terms of what could have been done, the Supreme Court noted that he should have, at the time of the appointment, disclosed first Chubb's identity as the common party in the arbitration. The arbitrator should have also outlined the nature of the appointments in the subsequent references. And finally, what could have been done was a high-level statement that the subsequent references arose out of the same incident. In terms of the common law tests applied by the parties, finally, taking into account the relevant factors at the time of the hearing, the court refused to hold that the arbitrator should be removed. And the main bases for that were first, that Lord Hodge said that there was a lack of clarity in English law at the time about whether this legal duty of disclosure existed and whether such disclosure was necessary. Second, the time sequence was important for the Supreme Court in terms of the three references, and the time sequence meant that in this case, disclosure was not needed. Third, in terms of this case, there was not overlap between the references. And again, the Supreme Court saw that as important. And finally, in the words of the Supreme Court, there was no question of the arbitrator having received any secret financial benefit, and to find otherwise would result in every party appointed arbitrator receiving a disqualifying benefit. So that's just a quick whistle-stop tour of the Supreme Court judgment and reasoning to make way for the discussion for our panel.
Thank you very much indeed, Ruth. I'm going to ask Edwin Glasgow to give us a quick overview before I descend into some of the general principles and then go on a little bit later some of the more specific one-off points that arise out of this judgment that may give rise to trouble in the future. Edwin, could you perhaps help us with that?
Yes, Paul, I'll take it as shortly as I can following that magnificent summary, for which I'm very grateful. I wouldn't flatter myself to think that anybody would be in the slightest bit interested in my views on the reasoning of five most distinguished Supreme Court judges. They have spoken, and what they say the law is the law, at least in our jurisdiction. As arbitrators, and indeed as counsel, we have got to get on and make it work. In trying to do that, it seems to me that what may really matter is that we do what we can to convince those of our international colleagues who will not be happy with all parts of this judgment, that whatever the law may be, we are going to apply it in a way which may reflect a bit more respect for internationally acknowledged norms than has perhaps been blindingly obvious to date. That said, I confess that I do feel that there are some points on which I, as someone who not infrequently has to struggle with what I should and what I properly can disclose, I would have welcomed a bit more practical guidance. But speaking for myself, even in those cases when not contractually bound by the terms of appointment, like those of the LCIA or the ICC, I personally will continue to think about my duty to disclose possible conflicts by reference to what I honestly think the parties would reasonably expect of me and nothing else. I do hope it won't sound disrespectful, because it most certainly isn't intended to. But I venture to suggest that despite the affectionate admiration that we all have for all of these eminent judges, the international arbitration community might be forgiven for thinking that the library of Bermuda form awards, which they either individually or collectively have written or contributed to, is comparatively small. But perhaps we learned yet again over the weekend that the best rugby referees are those whose playing careers were relatively minor and who excelled in other fields. But I repeat, making it work in practice is what seems to me to matter more than anything else. And we will do that. Although, may I confess as a side that I fear that some of our international colleagues who have appointed arbitrators in $100 million disputes might be a little surprised, I think, to be told that they, and I quote, must expect arbitrators to take further appointments to acquire the experience needed. That, with the greatest respect to Lady Arden, does seem to me to do for Bermuda form arbitration what Dominic Cummings did for eye testing. But those are my only comments, Paul, and I hand on to the better
very
knowledge.
much indeed. We've seen from Ruth's masterful summary that this consideration of this starts with the existence of the duty to disclose, and we've had clarification of that duty and clarification of its content, not perhaps to the extent that one can have a manual when one is seeking to disclose these matters. But we've then had the Supreme Court looking at accepting that the arbitrator was in breach of his duty to disclose, but nevertheless deciding that he should not be removed, starting with the process of looking at that not at the time of the appointment, but by the time that the matter came to court, and looking at it through so-called objective eyes rather than through the eyes of the parties. So what one sees is the confirmation of the duty, determination that there has been a breach of it, but nevertheless a failure to remove based upon both the time of the decision and the nature of the test. And Ruth told us the four things that the arbitrator had on his side to avoid him being removed. David, I'm going to ask you, please, if you would perhaps start with your reaction to the decision generally, but particularly in the context of that.
Yes, thank you, Paul. Just one preliminary observation. Reading the judgment, I was surprised that the court appointed Mr. Rogenson in the first place, because he had disclosed certain appointments with Chubb, and Halliburton had objected, but nonetheless the court went ahead and appointed him. I hazard a guess that many institutions would probably have not appointed him in similar circumstances. Indeed, Professor Park, in his final partial award on this case, stated that one side secured the appointment of its chosen candidate to chair this case over protest from the other side. Now, dealing with the objective test and finding of no apparent bias, despite concluding that Mr. Rogenson had a legal duty to disclose his appointment in the subsequent reference number 2, involving the respondent and Transocean, and breached his duty, it held that a fair-minded and informed observer would have not inferred from Mr. Rogenson's failure to make disclosure there was a real possibility of bias. And I'm sorry, Edmund, but I'm going to take a look at some of the reasoning of these learned judges. Being in Singapore, I can escape the verbal abuse in Fleet Street by judges after this. The first point is that transocean arbitrations had commenced several months after the Halliburton arbitration. I don't see this as a point at all because there's a continuing duty to disclose throughout the arbitration. Mr. Rokinson's measured and temperate response to a challenge. I'm reminded of the Coakley Limited Bingham Knowles case, which one of my colleagues will deal with, where an aggressive reaction to a challenge had been one reason for his removal. So Mr. Rokinson's response was exactly what was required. Nonetheless, he had been appointed in multiple arbitrations by the same party. He consciously had not made disclosure of references 2 and 3. And in paragraph 143 of Lord Hudge's judgment, he observed if Halliburton had been aware of his appointment in reference 2, it might have had concerns about the inequality of knowledge and opportunities to communicate with the arbitrator. Such circumstances, he said, might reasonably cause an objective observer to conclude there's a real possibility of bias. Exactly, but in this case, they found no bias. And perhaps the most important one, which would give a plausible reason for no bias, that basically at the time of Halliburton found out about he had not disclosed in references 2 and 3 was about the time that Mr. Rokinson was considering preliminary issues with the tribunals on 2 and 3 concerning which if favourable to Chubb would have disposed of the references. And I think that's a fair point. The court also considered that there was no overlap. He also provided an explanation of his oversight, which was accepted by Halliburton. So I think these are the most plausible reasons. Also, he did not receive a secret financial benefit. The point about allowing for lack of clarity in law as a basis, with respect, there's a statutory duty of impartiality, which must mean disclosure of circumstances of possible bias, but that one doesn't stand. In my opinion, from the international perspective, this decision will be viewed with some disquiet by many institutions and users and lawyers, hence the interventions during the Supreme Court case. First, no sanctions for a clear material failure to disclose. Mention is made of being sued, but that will be dealt with later by one of my colleagues. As I mentioned, the multiple appointments, 2 of which he did not disclose consciously. It's clear he had consulted the IBA rules, but reached the conclusion there was nothing to disclose. Are the institutional tests based on a subjective test or the perceptions of the parties a better test than this objective one from judges of the court? It's a matter for discussion, because judges whose experience are likely to have more confidence in an eminent legal arbitrator insulating himself from unconscious bias, but it may not be justified to have that confidence. Also, I venture to suggest that a professional background of judges is more likely to make them impressed with reputation experience of a well-known legal arbitrator. So I would suggest that this decision will not please all people. There are some issues, I think, which will cause concern, but it is the law in England, as Edward mentioned.
Can I just throw in there, David, if I could, please,
Yep.
a question which has been raised as to whether or not when an arbitrator is in material breach of this now duty to disclose, whether that ought to create an automatic or presumption of his removal.
I don't think so. You have to look at each particular case on its merits, because it may well be in a particular case that it should not be automatic because there are good reasons for that. So I don't agree that it should be automatic.
One of the things about this decision, obviously, is it focuses on Mr. Rokerson's failure to disclose, inadvertent, etc., etc. But of course, it doesn't answer the question that day to day, those of us at the coalface in this world need to think about. Namely, if Mr. Rokerson had disclosed at the time of appointment, what would the position have been? Would the declared overlaps, etc., have disqualified him? I think that's, for me, one of the less helpful factors of the decision. It ends up focusing on what might be seen to be dancing on a pin as to the difference between the test for disclosure as at the time of appointment and the test for removal as at the time of the application, which the sort of clever lawyers love, but doesn't do you much good in the international arbitral community. David
we
Bridmore
don't
Thomas.
know what would have happened, but presumably Halliburton would have objected, and then it would have had to be dealt with at the time. But if he had still maintained, despite Halliburton's objection, he should continue, then that's another matter. But if it had been institutional, it might have been taken care of by them.
One has the perception, David, would you agree with this, that if an institution had been faced with this conflict, it would not have appointed him, whereas the court, it looks as would not have had the same concerns. Judging from
Well,
the facts.
I agree with that, which is why I mentioned at the beginning that I was surprised he was appointed in the first place, despite objections, despite disclosing he had been appointed by Chubb in other arbitration. So just to finish up, so to not take too much time, I very much sympathize with fellow arbitrators in grappling with disclosure obligations in the future, because it does appear that in some respects, English law now differs from obligation and institutional rules. But I think they should be guided by the principle, be careful not to disclose when you need not disclose, but also be careful to disclose when you need to. So I have sympathy with my arbitrators from now on, based on this.
Walk that tightrope, David, is the answer. David Bridmore Thomas, could you perhaps give us your take on this?
Paul, thank you, and thank you, Ruth and David, for picking up many of the cardinal points in that. I think just taking this in stages. First, as a general observation, one of the criticisms in 1996, when the Act was passed, was that England and Wales did not take the opportunity to pass the Unstrau model law. That was well discussed by Michael Mustel, but nor was the opportunity taken to codify English arbitration law in the Act. The criticism has been made that it is not possible for a party coming to the United Kingdom or to England and Wales to pick up the Act and understand English arbitration law. And I have to say, I think that regrettably, this case makes that worse, not better. If anything, it balkanizes English arbitration. Not only must one make the distinction now between the old-fashioned distinction between a domestic and a non-domestic arbitration and the likes, what one must now do is look and say, well, is this, for example, an ad hoc arbitration such as a Bermuda form arbitration, which may be subject to one set of rules and practices, or is it one of the trade arbitrations, or is it something different? So I think that is a regrettable inference from this case. But the way I think that the tightrope that you invited me to walk is to be walked, Paul, is with the balancing bar of the institutions. Lady Arden, at paragraph 171 of her judgment, this is a point where she's discussing the fact that the two arbitrations may not be subject to the same rules or institutions. But she says arbitration under institutional rules, such as the rules of the LCIA, may involve their own rules as to disclosure of interests, making it unnecessary to consider the position under the general law. And so for convenience, and without underestimating their important role in international commercial arbitration, I leave them on one side at this point. I think that's a marked understatement of the importance of the international institutions to a lot of the international arbitration market. And effectively, in one sentence, Lady Arden dismisses the problems that Halliburton creates for much of the international arbitration community, because the test to be applied will not be the common law test. It may be informed by the common law test. It may be that the parties cannot restrict themselves to a narrower test, but certainly looking at the statement of independence that is given by an ICC arbitrator, that is that the arbitrator is conscious that they should disclose matters because they might be of such a nature as to call into question my independence of the eyes of any of the parties.
Those are the key words, aren't they? In the eyes
Yes,
of the parties.
the eyes of the parties, which Lord Hodge eschews and criticizes, and no circumstances that could give rise to reasonable doubts as to my impartiality. I think the first question is not what test is to be applied, it is you apply the institutional test. And secondly, and then the balancing bar that you offered me of the institutions is this. a party in Halliburton's position in this case would have had to make an application to the commercial court with the difficulty that we saw occurring in this circumstance to challenge the appointment. That is a challenge which has a certain threshold. The institutions, on the other hand, are very, very, very experienced at policing these sorts of declarations, and they're very experienced at dealing with challenges that arise from declarations or other facts and matters without necessarily even disclosing who has raised a concern about the declaration. So I think that the answer is, what should Halliburton have done? What could Halliburton do? They could have applied to the commercial court. Problem there, but problem solved if in fact you have an institution applying its own test that it is familiar with dealing with. It's familiar with dealing with really as an administrative matter, which takes us back to Saudi cable back in 2000. It's used to dealing with on a quick basis, an administrative basis, and without undue cost. So I think that actually this might be criticized, but it may be very, very good news in the long run for the institutions.
That's very helpful. Thank you very much. Interesting how it brings the institutions very much into the fore. And that perhaps isn't surprising, because the institutions are the specialist bodies, which, with no disrespect to the Supreme Court, whether they're trying Bermuda form cases every day or not, they're certainly not dealing with points of arbitration practice every day. Yeah. Karishma, from a perspective from India, from an Indian practitioner, and as well as a UK practitioner, can you, working between the two and in Southeast Asia, what's your perception of how this would work?
Yes, I mean, I would have to agree. The difficulties are the sort of disconnect between the institutional rules and what now has become common law. But yes, this problem arises because of the unique nature of the Bermuda form arbitration, doesn't it? Because the Bermuda form is an ad hoc arbitration, not institutional, governed by New York law, but seated in London. And taking on from there, there are 2 points mainly that I would like to discuss. The first is, what is the impact of disclosure? And that answers, Paul, your question to David earlier. And the second, what is the effect on enforcement? Taking each in turn, what is the impact of disclosure? Of course, we as officers of the English courts will comply by making disclosure of multiple arbitrator appointments. But what impact does it have on parties who are not satisfied following this disclosure? Do these parties have a choice? Mr. Rokeson in this case was not criticized for his conduct, but also Halliburton did not allege actual bias either. The appeal was argued on the basis of an appearance of bias stemming from non-disclosure. So the question is, does disclosure cure the bias? The judgment indicates that disclosure is necessary because it gives an opportunity to the party that is not common between the 2 arbitrations to address the issue. Halliburton argued, and the court noted, that if an arbitrator rules on an issue in one arbitration, the common party will know the arbitrator's approach and will have the advantage of modifying their submissions if they'd like to in the other arbitration. The party that is not common to the 2 arbitrations, however, will be blind to the arbitrator's approach and will not have that advantage. Now, unlike court proceedings, arbitrations are private, as Ruth said, and there's a substantive part of the judgment dedicated to this. Arbitrations are private, and therefore there is asymmetry of information. Unlike court proceedings, one party cannot nominate a junior lawyer, for example, to go on and sit and hear and make notes of the other arbitration. So what can this non-common party do? While the judgment says that disclosure provides an opportunity to this non-common party, it doesn't go as far as to say what this opportunity is. So there could be a couple of solutions, although I would not portray these as solutions unless they are actually part of the code or common law. One solution, for example, is, or one thought that might occur to the parties is, could an award which has been passed in one arbitration be disclosed in the other? But the question is, would that even cure the mischief? Any party to an arbitration has an opportunity to communicate with the arbitrator, and this wider range of communication would still be, the non-common party would still be prevented from this wider range of communication, even if an award was disclosed to the other arbitration. But this doesn't answer the question as now appears or is raised following this judgment, because confidentiality under English law has been put at a premium to the duty of disclosure. And in those circumstances, it's not possible to have communications or awards from one arbitration disclosed in the other. So that leaves only one opportunity to the non-common party, and that is to challenge the appointment of the arbitrator. And that's about it. That's as far as this judgment goes. The second point is the effect on enforcement. And I guess I address this issue wearing my Indian law hat rather than my English law hat. This judgment is a little bit limited in its approach because it only deals with multiple arbitrations where there is one common party between the two and one common arbitrator. But there can be a number of different issues. For example, there can be string arbitrations, and these occur quite regularly in England as well, such as before GAFTA or the Refined Sugar Association, sometimes the London Metal Exchange as well. Here, let's say a buyer of sugar decides halfway through the voyage that they no longer want to buy because prices are dropping. The seller has a duty to mitigate and tries to sell it to another party, but they fail to honor the purchase contract as well. So now we have two arbitrations, the seller against the first buyer and the seller against the second buyer. Let's say these were governed by the Refined Sugar Association. Would the Refined Sugar Association be able to appoint the same three arbitrators in both arbitrations? I have found myself in this difficulty once before, and my take on it, although this remains to be tested, is international courts and for example, Indian courts would not view very favorably enforcement of arbitrators who may have had an opportunity even of inconsistent decisions in parallel arbitrations, because under English law, they have to approach each arbitration afresh. The second situation, which is not covered by Halliburton and Chubb, is where an arbitrator is repeatedly appointed by the same party or law firm. For example, in large defense contracts, a government placing an order will often retain the right to appoint a sole arbitrator of their choice and perhaps repeatedly appoint this individual. I also found authorities where in other Commonwealth jurisdictions, financial institutions appointed the same arbitrator, and in one case, 2,278 times against various borrowers who had defaulted. And this has been covered in IBA guidelines. And the IBA guidelines, of course, set out a red list of waivable list, a red non-waivable list, and an orange list. And many countries around the world have adopted provisions from these lists into their law. And this comes back to David Brinmore Thomas's point about codification or the lack of codification under English law. So if the IBA orange list, and I'll read out a particular point that deals with multiple arbitrator appointments. The orange list says the arbitrator has, within the past 3 years, been appointed as an arbitrator on 2 or more occasions by one of the parties or an affiliate of one of the parties. That is enough, and that has been codified and adopted from the IBA guidelines into various Commonwealth laws around the world. That is enough to challenge the arbitrator's appointment, and the party challenging is likely to win. It doesn't match, of course, with Halliburton and Chubb, and there lies the difficulty, in my view, with enforcement.
Thank you very much indeed. I'm going to ask Vivek in a minute to pick up the general threads, but also to talk about the multiple appointments and the frequent flyers. But before that, Edwin, I think there's a point you wanted to make.
Oh, it was a very, very small one. It's just the point about the criticisms of Ken Rokerson. I think we have to accept that there were criticisms of Ken, and perhaps we can honestly say the sort of elephant in the room in this case has always been that it was Ken Rokerson. There can be nobody who doesn't hold him in huge admiration and respect, and indeed affection. And the blunt truth is that if I had made the mistake that he had made, I would have been out on my ear and told to put my colored crayons back in my school satchel and been suspended immediately. We've had all this problem because it was Ken. And we've spent a huge amount of time with enormously clever judges trying to do what half a century ago I used to do in the magistrates' court, trying to persuade people that it was only a very small gross indecency. Of course it was a mistake. He admitted it. If it had been made by anybody else, we would never have been where we are today. That's the trouble with very nice, very clever men.
Vivek, well, that's an introduction for you to then A, give us your thoughts, and B, talk about the term frequent flyers, which the excellent article written by Paul Stanley that highlights the use of that term and multiple appointments. Perhaps you could just tell us how you see it from that perspective. You're muted. You win the prize.
I indeed do. I think that the treatment of impartiality as a freestanding concept under Section 24 of the Arbitration Act is likely to leave many dissatisfied. When the IBA guidelines refer to the eyes of the parties, they focus on a distinctive characteristic of arbitration, which the court indeed recognizes. This essentially means that in an arbitration, the only observers are the parties because the parties have contracted to keep their disputes away from the public eyes. Now, the power to remove an arbitrator under the Arbitration Act, where there are justifiable doubts as to his impartiality, when gets equated to the common law test of bias, essentially means that the result is that in no separate bias, when the arbitrator can be removed for lack of independence if it does not amount to partiality. So understood. Now, the court was encouraged in that Section 24 of the Arbitration Act only provides for bias as understood by common law by the fact that independence, a requirement under UNCITRAL model law, was omitted. I think in this formulation, the aspect of preservation of confidence in the dispute resolution process is lost. There is a serious concern regarding the perception of London as a seat, especially amongst the foreign users of London arbitration. An English lawyer may take the view that the appointed arbitrator is a person known to him, has high integrity. Somebody in New York or New Delhi may not be as confident. And I think the point has already been made.
Might not bump into him in Fleet Street quite so often.
As for the legal obligation to disclose, the position is somewhat difficult to reconcile, especially in the international context. The court finds that there is a legal obligation to disclose, and then goes on to decide that the breach of that obligation has no consequences. And here again, the conclusion is reached and expressed in terms of English law, which in my opinion is one of the biggest exports of the United Kingdom. Now, turning to the problem of frequent flyers, I think there is a growing concern regarding frequent flyers, as they're sometimes known. And I think it has more than one dimension. The first and more obvious and important one is the fear, and I use the term consciously, that an arbitrator, through repeat appointments, may become predisposed to a particular party, a particular law firm, or parties belonging to a certain class, like insurers or policy holders in the context of this case, because of the repeat business that he or she receives from them. One of the reasons the court was not persuaded that the objective observer would have found a real possibility of bias on Mr. Robinson's part, because he received no secret financial benefit from his subsequent appointments. In my opinion, the problem was looking for a secret financial benefit is that the court is looking for a form of dishonesty to impugn bias. The repeat appointments are the not so secret benefit that raise justifiable doubts. And as David had said, the English courts have in the past, especially in Coughley Limited versus Bingham, which is the 2016 case, removed an arbitrator where about 1/5 of the arbitrator's business came from one party. And then there were other circumstantial material to point towards bias. Now, the second reason, which Krishma also alluded to, is that if an arbitrator has previously decided the similar issues in other cases, the fact is known to only one party, but not the other. And in the context of frequent flyers, the problem is frequent flyers are appointed by repeat players. who have an in-depth knowledge of the results and reasons of the arbitrator's previous awards in cases where they were parties. This in-depth knowledge can be deployed with great tactical advantage. Now, in investor-state arbitration, which is also plagued with the issue of repeat appointments, which tend to usually be from the investor side for some and the state side for the others, this problem is slightly less aggravated because the arbitrator's previous awards are mostly public and both parties essentially have the same knowledge. And I think finally, the point which was at the heart of this case is arbitrators who have previously decided other cases involving the same factual issues or simultaneously engaged in doing so have heard and seen evidence which will be known to one party and not the other. There is undoubtedly a risk that their minds may be influenced by that evidence. And finally, I think although multiple appointments do not constitute bias, they definitely give rise to justifiable doubts.
Can I just ask you a question as to whether this is an argument in favour of a larger pool of international arbitrators? I think it follows from what you say that would be a good idea in your view.
I absolutely, and I think that there have been even radical suggestions of a rule precluding multiple appointments, which will reduce the risk without significantly damaging arbitration and will also help achieve the goal of diversity and widening the pool, as you said.
I'm just going to pick up a couple of questions before we go on to next topics. One question we've had is whether the duty to disclose is a new one or whether it was always there. David Bateson, I think you and I take the view that the duty's always been there. It's just now better recognised after the Supreme Court.
The duty's always been there because the statutory duty of impartiality must mean to keep that, you must disclose when there's reasonable justified doubts about that. And the Court of Appeal had already found that there was a legal duty. The Supreme Court just confirmed that.
And the other question that we were asked of from a very distinguished arbitrator in Hong Kong, I think you were going to answer, David, as to whether there is a real danger in taking string arbitrations where you may discover facts in one that you can't put out of your mind in the other.
As I'm closest to Hong Kong, that individual's a friend of mine, I agreed to answer it.
Friend of mine too, so good morning.
Yes, quite. Yes, well, basically, if you look at paragraph 146 of the Lord Hodge judgment, he said that you can indeed infer consent to disclose without having to get express consent, the name of the common party, whether the appointment is by party appointment or court or institution, and a statement of fact generally that the reference arose out of the same subject matter. Beyond that, you would have to get express consent. So I think that's a good from the point of view. They shouldn't be concerned about dealing with multiple appointments on the same reference, subject to a proper disclosure, and assuming that there's no huge objection to that.
Before I ask David Brynmore Thomas to deal with the costs panic, which is what I'm calling it, I want to make 2 points. Firstly, we've had a very helpful intervention from a very distinguished senior arbitrator, pointing out that the pool of arbitrators available is in fact infinite because there are no requirements. I think that's a obviously correct statement, but I think that we have to recognise that the arbitral community, I wouldn't describe it as a club, a frequent flyers club completely, but the means of expanding those who are capable of appointed is going to be very good. I'm not going to take up time talking about how arbitrators are best advised to deal with these challenges if things go wrong, but it's certainly clear that Mr. Rokerson's conduct in the way in which he dealt with it, and pace apparently of some quite blunt correspondence to him, counted very much in his favour. The other side of the coin, which in the Coakley case, decided by Mr. Justice Hamden in his last case in the commercial court, where the arbitrator's reaction, which is, if I may say so, for those who are interested in this, worth a read, the transcript of his go at counsel who was asking these questions is not without interest. It is certainly right that arbitrators, if they do get themselves into this sort of difficulty, fighting your way out doesn't appear to be the best way to do it. Recognising it and taking on board the criticism and responding constructively and charmingly is obviously the way. As I say, Coakley and Bingham is a good read, as to how you, as to one way of dealing with it, that in those circumstances may get you in danger of being removed even if you weren't there before. We've got a few minutes left. I want to pick up one point that I know over the weekend, reading all the material and talking to colleagues across the world, has caused some interest. In paragraph 111 of the judgment, Lord Hodge says, secondly, in cases where the matter is serious, but the non-disclosure of the matter on later examination does not support the conclusion that there is apparent bias, the arbitrator might, depending on the circumstances, face an order to meet some or all of the costs of the unsuccessful challenger or bear the costs of his own defence. That's obviously something of a shock to those in the arbitral community. David, would you like to perhaps just introduce, as we finish, that topic as one to be looking forward to over the next few years?
Certainly. I mean, simply taking this as in stages, under the Arbitration Act 1996, an arbitrator has a statutory immunity against damages, save in circumstances where there has been bad faith. Arbitrators, as a result, tend not to appear, even on challenges under Section 24, let alone challenges under Section 67, 68, or 69. On the one occasion when I was instructed under a Section 24 case, it was expressly because the claimant had sought costs against the arbitrator. And when I explained that to the judge in the commercial court when I appeared, he said, "Oh, that explains why you're here." And as soon as the claimant indicated that in fact they weren't pressing a claim for costs against the arbitrator, I was invited to skedaddle, or at least it was observed that my presence was no longer really required. This passing comment in 111 is the only circumstance that I know of. I haven't been able to look much over the weekend where the court has expressly contemplated making an order against an arbitrator where there is a challenge to remove the arbitrator. As you've said, the quote is, in cases where the matter is serious, but the non-disclosure on later examination doesn't support the conclusion of apparent bias. But nonetheless, Lord Hodge is contemplating that there would be an order for costs against the arbitrator. In terms of the sort of income that arbitrators make, I realize that the view is that arbitrators are as rich as Croesus, but in fact, that would completely wipe out an arbitrator's fee income. One outing to the commercial court would wipe out fee income from an arbitration. I can see the insurance market responding to this in terms of arbitrators' PI. And I can see concerns also from the perspective that if a threat is made to an arbitrator in a challenge, what does the arbitrator do? Does the arbitrator say, well, what does the other party want to do? I will let the pair of you deal with it and I will stand back? Because then the arbitrator is unrepresented but may face an order as to costs. Does the arbitrator defend his or her position and face an order as to costs? Or does the arbitrator just say, I'm not going to risk costs, I'm gone, I'm resigning?
Well, all of that, David, as you say, is going to be very much one for the future. That's a sort of little hidden time bomb in there. Those of us who've represented, and I have on a number of occasions, arbitrators in court proceedings, very often advising them not to appear, simply to assist the court in whatever way, and to decline to take any part in the proceedings and try and protect themselves to costs. Those of us who do that sort of work are going to have to be looking very closely at that. Well, I promised this seminar would last an hour. We're nearly at the hour. I just want to put it together. I want to thank my colleagues for their universally excellent contributions. For me, this has been a fascinating seminar, and what I take out of it is, firstly, a certain unease at the way in which the Supreme Court has approached this from the point of view of the application of domestic English law principles to international arbitration. Secondly, I regret the fact that, notwithstanding the eminence of the arbitrator, the duty to not to disclose on the particular facts of this case did not simply lead to his removal. That would seem to me to be an appropriate sanction independent of the individual concerned, whose eminence and distinction we all recognise. But thirdly, the other thing I would just say at the end of this, if I may, for me, it's a disappointment. I'm an arbitration practitioner, both as counsel and as arbitrator. What one wants in this job is clear, simple, applicable guidelines that you can use. Now, I've spent quite a lot of time since Friday reading this judgment, and thanks to Ruth, understand quite a lot of it, I think, now. But nevertheless, there are judgment after judgment. By judgment, I mean decision for arbitrators, decisions for parties. And that may bring us back to David Brynmore Thomas's contribution, pointing out the benefit of the institutional arbitral rules, and of course, the difficulties that arise from the otherwise understandable decision for other reasons not to codify English law in the Arbitration Act 1996. But the reality is that we will, as Edwin said at the start of this, turning it back to where we began, as practitioners and arbitrators, will make this work. The institutions factor, I think, gives us the sort of assistance and protection to continue the eminence of London as an arbitration centre, looking at it from a London point of view, but recognising also and reflecting on 39's geographical presence, that this is going to be a matter that's going to be approached, I expect, differently in different jurisdictions. So may I, with all of that, repeat my thanks to my colleagues, repeat my thanks to you for doing us the great privilege of coming to listen to us talk and bring this seminar